Welcome to our first podcast, Let's Talk Law with Deloitte Legal. I'm Zvezdelina, I'm a lawyer, I love talking. I'm here with my colleagues Mila and Irena, they love talking as well. And today we're going to talk about the Omnibus Directive. What is it about? I guess it's not about buses and public transport, right? Yes, you're right. We have heard that Omnibus is a kind of bus, but today we are talking about the Omnibus Directive, which is the informal name given to the Directive on Better Enforcement and Modernization of Consumer Protection, which practically changes almost all previously existing directives on consumer protection and consumer rights. Has it already entered into force? Yes, it entered into force in 2020 and it was already implemented in the Bulgarian Consumer Protection Act, which happened the last year. What's the impact for the business? There are a lot of new applications which has to be fulfilled by the business. For example, the obligation for provision of information, much more information should be provided. Type of information, for example, contact information when there are ranking of search results, the trader should provide information on the parameters based on which the ranking was performed, and information about the importance of each of these parameters. Consumer, I'm mostly interested in pricing. Yeah, and the prices are hot topic. There are new applications related to the announcement of the prices and how the prices are reduced. The traders should now indicate the prior price when that, because it aims to cease manipulation of the consumers, which are usually performed by the Black Friday campaigns. And traders claim that there are reductions while there are no reductions. And the prior price is the price which has been applied by the trader for the same type of goods for a period which cannot be shortened than 30 days. What about withdrawal rights? I have bought a dress which unfortunately does not fit. Do I have the right to return? Yes, so you have the right to return it within 14 days. If it comes to distance contract or off-premises contract. But with regard to digital content, you have to be more patient because digital content, which is not provided on a durable medium like on a DVD, could be returned before the performance of the contract has begun. And I would like to also share with you something very important concerning unfair commercial practices, and more specifically about published reviews. I rely a lot on these reviews, yes, and sometimes they have totally contradictory. Yes, we have observed negative reviews published by competitors. But the purpose of the Omnibus Directive is to forbid fake reviews. So now traders are obliged to provide information whether and how they have and they ensure that consumers who have published reviews have actually ordered the respective product or the deliverable or service rightly, and how will the business be motivated to comply with the Omnibus Directive? Well, sanctions are going to be the major motivation because the fine could reach up to 4% of the annual 4% of the annual turnover of the trader. Of course, the exact amount is depending on different factors, for example, the nature of the offense, the scale of the offense, and if there are other mitigating or aggravating factors. Mm-hmm. And as a conclusion, what should the business do now? It is recommendable that businesses conduct the so-called sanity check, which will help them identify what are the gaps compared to the new requirements. And the recommendable steps that have to be undertaken are to revise their pricing policies, their terms and conditions, to provide transparency to their consumers, and of course to ensure personal data protection and compliance with the GDPR. As Mila already mentioned, sanctions are comparative to those under the GDPR, so businesses have to be more patient. Thank you, colleagues. That was really very interesting. So stay tuned.